harassment. So let's talk a little bit about that. Okay. So sexual harassment. So what exactly do those words mean? Okay. So the courts have extended Title VII protection to those who are subject to sexual harassment in the workplace. There we go. There are two types, everybody, of sexual harassment. Type 1 is called the quid pro quo harassment, which occurs when an employment superior gives awards. Okay, so an employment superior, meaning the employee's down here and the person's a little up here, manager, supervisor, whatever you want to call it, owner. Okay. So they give awards such as promotions, raises, benefits, or any other advantages to a subordinate, which is someone below them, someone they employ, in exchange for sexual favors. That is called quid pro quo harassment. So we hear a lot of people use the word sexual harassment. Now if we do work in this type of field, one thing you have to get, from your client is what took place, of course, and you have to label the harassment the correct label. So what type of sexual harassment is it? Does it fall into either one of these categories? Okay. So quid pro quo, remember, legal terms come a lot from Latin, right? So it's a Latin term, which means this for that. You do this and I'll give you that, right? That's what it means, okay? Or something for something, okay? In English. So in contrast, hostile environment harassment. This is the second type of sexual harassment. So you're not going to just put sexual harassment on the actual complaint. No, we need to know what type it falls into. Okay, so the second type is hostile environment harassment. Now, what does that mean? This occurs when an employee is subjected to offensive sexual comments. Okay, people are making sexual comments towards them. They're making jokes about them in a sexual way, or physical contact in the workplace that makes it difficult or impossible for the employee to perform a job satisfactorily. Okay, get a lot of cases on this. I think hostile environment harassment is a little bit more popular or happens a little more than the quid pro quo, but the quid pro quo also happens. So I guess maybe they're equal. I don't know. But if we look up cases, I would have to say hostile environment. There are more cases on it than the quid pro quo. Okay. So what do you think the hardest part is for this harassment and hostile environment harassment? Is the proof, the facts, right? We definitely have to get the facts here. What happened? Okay. And remember, if there were jokes involved, we want to know exactly what the jokes were. Well, I think they said, no, we need to know exactly what the joke was. And that's the part that gets clients because when you're in a situation like this and you hear a joke, I mean, who remembers it word for word or, things like that? But in honesty, we have to have the facts. We can't go to court and put our client on the stand and say, so what was the joke? What happened? Oh, well, I think that the defendant stated this. Since we're a court of fairness, we really do need to know what was the joke, right? Not exact, if you're missing an and a the, I get it, but why was it offensive, right? Sexually offensive. Why? So what was the joke about? Or did you just take it as it being sexually offended? Now, a joke that is sexually offensive versus a joke that was you took it as sexually offensive are two different things. And this is why when it comes to these type of cases, attorneys are pros because they have to work with two different things here. That's it. So they know this, and as soon as they start hearing facts, and they know right away if they have a case. It is so specific. The facts have to be so specific that it's not just you felt. Okay, the joke was a sexual joke. It absolutely was, right? So there's a difference, okay? Anyhow, so it's really specific. If you guys want to really get down to the nitty-gritty of what is an offensive joke or what is a sexual comment, you would go look at cases, okay? Especially in California. All right. So, and then you have to prove that your client could not perform their job satisfactorily because somebody made a joke. Okay, the joke was sexual in nature. Let's just say it was. Okay, so the second question. So why couldn't you perform your job? Well, they were walking around. Yeah, I don't even know an example. I've never actually, we got to look up some cases on this, but maybe they were walking around saying the joke to others, or you would come in the office and people would just automatically start laughing because the joke is around the office, things like that. So it's got to be so, like it says, so difficult or impossible to perform your job. What's the hardest part of that? The facts. Was it absolutely impossible for you to perform your job? Was it so difficult that you couldn't perform your job? Was that joke just, making it so difficult to perform, right? So those are the kind of things you have to ask your client. And just by me saying that, I can hear clients saying, well, if I figure it was difficult to me, right? That joke was horrible. It was difficult but how was it difficult for you to stop so clients are going to get offensive at this point because you're questioning them so much. Because we have to have the facts and we have to be able to prove it in court. It's not because we don't want our client to benefit and get damages or, they've been off of work, so get those damages or remedies. That's not the point. The point is the judges go by law, right? And if they don't have the facts and we don't have the facts, how are we going to even get this past the judge? So, like I said, clients don't understand that. It can happen with any type of case, though, everybody. It can be torts, it can be contracts where they just feel like they need to be compensated. Okay, well, we feel like you need to be compensated too, but we have to have the facts to prove that you need to be compensated too. It's not just because you feel like it, right? So feelings come into effect a lot when it comes to stuff like this. And we don't go off feelings. What do we go off of? The facts, right? What are the facts of your case? Okay. All right. So these are often hard to prove. This generally requires that the harasser, the person making the jokes or the sexual comments or the physical contact in the workplace, target employees of a particular sex rather than all the employees. What if that's happening? So what if the harasser's just going around making jokes about everybody in the place, men, women, tall, short, whatever? That's all the employees. Remember, you have to find the harasser just harassing just you, putting you to the side and harassing you. Do you see what I'm saying? If someone's going around making jokes about everybody, that's not particularly pointed at only you. So there's more questions that come out of this. So there's more questions you have to start asking your client. Okay? So a supervisor who makes off-color jokes to male and females. So his jokes are just not funny. His or her jokes are not funny. They're going to men and women alike. It's poorly behaved. We're going to tell them you are poorly behaved and rude, and you're being rude, but it is not likely to be engaged in sexual harassment. You have to be talking to that one person, okay? And then we can prove it in court. He just has this naturally rude, poor behavior. It's not pointed at you, it's pointed at everybody in the office. Okay? That is different. A supervisor who tells jokes only